Adopted on July 9th of 1868, the 14th Amendment to the U.S. Constitution provided a broad definition of a national citizenship by stating that all persons born or naturalized in the United States were citizens of both the United States and of the state wherein they reside. The amendment also contained two very notable clauses: the Due Process Clause, which is responsible for the application of the Bill of Rights to the states, and the Equal Protection Clause, which holds that states must provide equal protection under the law for all people within its jurisdiction. When the amendment was adopted in 1868, it was intended to redefine citizenship to include and protect the newly freed African Americans during Reconstruction. From its first application in the slaughterhouse cases of 1873, however, the fate of the 14th Amendment faced an unanticipated twist. In 1886, corporations were given the status of persons with respect to the Equal Protection Clause, thus awarding corporations all the same rights as people. Despite this initial betrayal, later, more fair-minded interpretations of the 14th Amendment by the Supreme Court have opened the way to furthering equal protection and due process rights of minority groups.
Steel Incorporated has many of the legal rights of a person. It can buy and sell property. It can borrow money. It can sue in court and be sued. It carries on a business.
In 1886, the 14th Amendment was misinterpreted to protect the rights of corporations from government interference and regulation in Santa Clara versus Southern Pacific Railroad. The California Constitutional Convention of 1878 to 1879 decided that railroads could not deduct the amount of their debts from the taxable value of their property, which was a right that individuals possessed. Under these circumstances, the Southern Pacific Railroad refused to pay taxes, and Santa Clara County and few others filed a suit against the railroads. Eventually, Southern Pacific was able to appeal all the way to the U.S. Supreme Court, where it was ruled that counties could not collect taxes from the railroad. More importantly, though, the decision established corporate personhood. Under the Equal Protection Clause of the 14th Amendment, private corporations were entitled to the same constitutional rights and protections as an individual.
1890 and 1910, there were 307 cases brought before the court under the 14th Amendment. 288 of these brought by corporations, 19 by African Americans.
Corporations have since used their status as legal persons to rise as the dominant institution of the day, permeating nearly every aspect of today's society. Corporations are responsible for the production of nearly every item we utilize in our everyday lives, which accounts for both why they are so ingrained in and essential to our society. However, profit-driven corporations conduct most of their production in underprivileged countries, gaining access to cheap labor and causing many to see corporate practices as inhumane and exploitative. Whether or not private corporations do more harm or more good does not change the fact that they are powerful and ubiquitous, and this was facilitated by the application of the 14th Amendment to the status of corporations.
And they say, oh, you can't deprive a person of life, liberty, or property. We are a person. A corporation is a person. And the Supreme Court goes along with that.
Since the inception of the 14th Amendment, interpretations have continued to evolve. In the 1896 case of Plessy v. Ferguson, the amendment that was adopted with the intention of protecting African Americans by broadening national citizenship was instead used to legitimize racial segregation under the separate but equal doctrine. Plessy set the precedent for the legal segregation of facilities for blacks and whites, which extended into nearly all aspects of public life, especially in the South, where the segregation supported Jim Crow laws, poll taxes, and literacy tests that virtually disenfranchised African Americans. Led by Chief Justice Melville Fuller, the Supreme Court's 7-1 decision that the Equal Protection Clause of the 14th Amendment supported the separate but equal doctrine reflected this conservative court.
In 1909, the NAACP was established by a group of mainly white liberals with the aim of protecting the rights guaranteed in the 13th, 14th, and 15th Amendments. By 1913, the NAACP had branched into several major cities, but the political and economic crises of World War I, the Great Depression, and World War II slowed movement toward any substantial political, social, economic, or educational equality for minorities in the United States. With NAACP assistance, a class action lawsuit aimed at reversing racial discrimination in a Topeka, Kansas school district worked its way up to the Supreme Court in 1954. In the Brown v. Board of Education decision, the Supreme Court took a new stance regarding the 14th Amendment by overturning the separate but equal doctrine.
During the New Deal, the expansion of corporate powers was curtailed to some extent and did not gain momentum again until the Reagan administration in the 1980s. Since then, corporations have continued to accrue power, culminating in the recent Supreme Court case of Citizens United versus FEC, which provided for unlimited corporate funding of independent political broadcasts, thus giving corporations the right to free speech.
It's time to put strict limits on the contributions that lobbyists give to candidates for federal office. With all due deference to separation of powers, last week the Supreme Court reversed a century of law that I believe will open the floodgates for special interests, including foreign corporations, to spend without limit in our elections.
In addition, the Supreme Court utilized the idea of substantive due process, which is the protection of fundamental rights in the 14th Amendment to guarantee our right to privacy, which serves as the buffer between the individual and the state. In the 1973 landmark Supreme Court case, Roe v. Wade, the court limited state involvement in abortion, resting their conclusions on a constitutional right to privacy from the Due Process Clause of the 14th Amendment.
However, the legitimacy of substantive due process is debated, since it is not enumerated in the 14th Amendment. Justice Antonin Scalia asserted that the entire practice of using the Due Process Clause to add judicially favored rights to the limitations upon democracy set forth in the Bill of Rights is, in my view, judicial usurpation.
Somebody has to make that call. I don't mean to minimize the importance of somebody making that call. But it's not a lawyer, it's not a judge. It's a legislature that makes those calls.
Despite objections to substantive due process, the Supreme Court has continued to make rulings that further fundamental liberties that may have not been enumerated in the Constitution.
Interpretations of the 14th Amendment, originally intended to define and expand the national citizenship, have been taken to new levels, eventually expanding so much as to serve as the basis of corporate personhood and provide corporations with a right to free speech. But the amendment is also being used as grounds for further equality. The Equal Protection Clause of the amendment served as the basis for affirmative action, which gives equal protection to underrepresented or previously oppressed minorities and women by taking positive steps to increase their representation in regards to employment or education. In recent years, advocates for gay rights have called on the Equal Protection Clause of the 14th Amendment to argue that it should offer protection for same-sex couples who wish to marry. 5 states have thus legalized same-sex marriage on these grounds.
The Equal Protection Guarantee was aimed primarily to protect the freed slaves, African Americans, but it's been read more expansively to protect women, other racial minorities, people with disabilities, etc. So it really changed the entire nature of our constitutional government.
Later transformations of the application of the amendment reflect changes in interpretation related to changes in economic and political context. Although early readings of the 14th Amendment gave great power to corporations, its complex nature also provides great potential for the rights of minorities.
Early to say, at least at the federal level, what protection, again, lesbian citizens or same-sex couples will have under the 14th Amendment. We may not know that for a lot of years.
Ultimately, it has and could continue to help create a more open, democratic society in which all people from different ethnicities, backgrounds, and beliefs have rights to equal protection and due process.